Today, IR35 and what it means for you. I know as folk in media aren't very good or don't necessarily enjoy this sort of the legal side of things, tend to be a bit more creative, but we've got Rhys Thomas joining us who will make IR35 creative, interesting, answer all those questions. He makes it very easy to understand. We've been working with Rhys now for over a year. With WTT Legal and also his IR35 Navigator. As I say, he makes it very simple. He has got a partnership with us, so I'm sure there'll be questions that might be relevant for you after this session. And do get in touch and we'll tell you how. But as always, we want it to be quite interactive. So if you do think of things that are questions as they come up, let us know, put it in the chat, and hopefully we'll have a bit of time at the end where we can answer some of those questions too. So on that note, I'm going to hand over to Rhys to tell you all about IR35.
Thank you very much. IR35 being billed as fun and exciting is perhaps the first time I've ever heard that. So I feel like that's quite a bit to live up to initially, but I'll try and make it as interesting as it possibly could ever be considered. Good afternoon, everyone. Thank you very much for attending today. I'm going to just kind of jump in and cover off what we're going to talk over today. I'm aware that we're kind of not pressed for time. We've got plenty of time, but want to rifle through this kind of initial section so that we can get some questions and take some interactive approach from the membership. Which I think often helps the situation a little bit more to relay things back. So what we're going to talk to you today, it's a fairly full bill, but we're going to just have a quick introduction, a history to IR35 very briefly, talk around the recent reforms. Those are commonly known as the off-payroll rules. We'll then move on to who it applies to. And I'm conscious that we have all sorts of people sitting in different places along the supply chain on the call today. So it will be fairly broad. It's not going to specify to one particular area in the supply chain. But as I say, if you've got any questions that relate specifically to your part of it, then feel free to ask throughout. We'll talk around the important considerations that we need to think about when affecting or assessing or analysing IR35. We'll also talk briefly on the disagreement process and what everyone in the supply chain needs to be aware of when the disagreement process is invoked. We'll touch very briefly on alternative models to the traditional approach. And then, as I say, Q&A. However, throughout the session, if you have any questions, please do drop them there in the chat box and we'll jump onto them. Kate's looking on those and we'll keep a monitor on everything. Okay, so who are WTT? First question, who am I to be talking to you today? We, as in WTT Group, are a tax and legal professional services firm. We are an SRA regulated law firm and a CIOT regulated tax advisory firm. And we basically service the entire supply chain from an advisory perspective. Our focus is on the contingent workforce, making sure that powerhouse continues to be a powerhouse into the future in spite of new provisions, regulations and actions, should we say, of HMRC causing it some detriment, but it's growing. It's more important than ever, and certainly following COVID, it's going to be more important to the country's resurgence. So we are professional advisors to the contingent supply chain. We sit in there and we advise all entities along that supply chain on their compliance needs, on their legal regulations and their tax needs. And those focus on tax investigations as well. So we take knowledge from the past on tax investigations and we move it into the future. And I think you're going to see why that's quite important on IR35, given the lack of guidance and the fact that a lot of it is pretty much based on historic court cases. So the history of IR35, first introduced way back in 2000. I know that a lot of people think it's a new thing. It is not. It's been around for a long time and has contributed to a lot of changes in the contracting supply chain over the years. It was so called because the HMRC back then, Inland Revenue, issued their press releases, and number 35, IR35, was their press release that announced it. So there's some perhaps some unknown history, but that's why IR35 is stuck and called it that. As you may or may not know, it was initially reformed for the public sector in 2017, and we've seen a swathe of big penalties and fines coming out to public sector bodies for getting IR35 wrong post the reforms in 2017. So we're quite keenly looking on those examples and learning from that and seeing how we can make sure that that doesn't impact us going forward on our assessments. So lots to be learned from the public sector rollout 2017. It was then delayed. It's due to come in April 2020 and was delayed in April 2021 for the private sector due to COVID. It's now with us. We did anticipate perhaps another delay, but it is now with us and is now in place. And I'm certain that some of you on the call who are contractors may have felt the pinch already of it. And I'm even more certain that those of you who are companies and hirers will have felt the frustration of having to change processes. So it is with us. It is at the moment here to stay, and we need to understand how we deal with it and what we're going to do to take it forward. So that's a brief history. Moving on to the reforms. The purpose of the reforms is not IR35 now. We're talking about the reforms that took place in 2017 and 2021, respectively, for the public and private sector. They were created to change the party responsible for making the determination. Now, that's a really important provision to consider, because previously the limited companies, i.e. the consultancy companies who contractors work through, made the decision, ran the assessments, decided whether they were determined to be self-employed or employed for the purposes of tax. And that's all well and good, but HMRC have to take a number of cases against individual limited companies to try and recover any leakage of tax. And HMRC don't like that. The nature of IR35 is that it's very circumstance dependent. And so where a normal tax case may apply to a much wider population of people, that can't be said here. So IR35 has changed to try and streamline how the recovery of leakage of tax is changed. So now the responsible party for assessing IR35 has shifted up to the end client. The end client, i.e. the hirer, the company hiring the consultant, must now make the assessment pending certain circumstances, which we'll come on to. And that's very important for HMRC, because now they can go to the end client and say, well, you've got 20 consultants all working in this pattern. You made this assessment, you got it wrong. You owe us X thousands of pounds in leakage of tax, rather than having to go against 20 individual limited companies and take 20 court cases. So it's a streamlining of the recovery of tax is the purpose for why they've done this. It's quite clever when you think about it. It's quite restrictive and damaging, but it is quite clever in how they've approached it to pull the responsibility up the chain. The end hirers are notoriously risk adverse in the main. They don't want to do anything which invites a load of tax. And so that shift in person or entity determining tax status has shifted up to that party who is more risk adverse. So that's what's been designed to do, and that's really the purpose of the off-payroll rules. As I say there, it changes the liable party for any lost tax from the worker to the fee payer. The fee payer is the one entity above the intermediary. So if the consultant is working through their limited company, it is the entity above that limited company, be that agency, if there's a recruitment agency in the chain, or if it's a direct arrangement between the end hirer and the consultant, The liable party for the purpose of the fee payer is therefore the end hirer. Most importantly, therefore, it requires a joined up supply chain. Previously, there has been this notion with IR35, there's a bit of a conflict between parties. One may say I'm inside IR35, one may say outside IR35. There may be one trying to protect their indemnities, one trying to escape indemnities. We need to start thinking about the supply chain in a much more progressive and transparent way. We need to open up those discussions. Everyone in the supply chain should be fully understanding of their position on IR35. If they're fully understanding of their position on IR35, they are limiting their risk naturally. And by limiting the risk and limiting exposure, you create a much more transparent, cohesive workforce, which is going to create much more commercial credit for a company and much more long-term productivity for you as a consultant. So we're really encouraging this much more joined up, transparent supply chain communication, and we'll explain why that's important for the purposes of reasonable care shortly. That reasonable care point also shows that hirers now, i.e. the fee payer, must do further due diligence, must do it. So first question, who does it apply to? We have previously provided Liberty Hive's community with flowcharts. They're interactive flowcharts. They run through all the stages of I am this entity, this is how I'm working, therefore this is how IR35 should apply. We'll resend those out to everyone after the webinar and make sure you've all got them. But in every one of those flowcharts, regardless if you're a consultant, an end hirer, recruitment agency, wherever you start, it's who does this apply to? And that's how we have to start this discussion. So any consultant providing their services via a personal services company, i.e. a small limited company, or a partnership. This means where you're a sole trader and you're taxed on all your profits as if they're employment income, or you're utilizing the services as a sole trader, off payroll rules are not applying to you. So this discussion isn't necessarily applicable for the purposes of tax, where you are using a sole trader or you are a sole trader. The IR35 rules and the off payroll rules apply to any consultant providing services via an intermediary, which is most commonly a personal services company or a small limited company or partnership. So moving that on then, let's assume the consultant is providing their services through a small limited company and therefore the IR35 and off payroll rules in principle do apply. Are there any further exclusions to the rule that off payroll has now been implemented? The answer is yes. And that is around whether, or it's called the small companies exemption. It looks at where small companies, i.e. the small company hiring the consultant or employing the consultant's services, hit the criteria for being a small company, they sit outside of the off payroll reforms. Now, that's really important because if you're a small company hiring the services of a consultant, the old rules apply. That means you as the company don't need to go through this assessment criteria. You as the company and the fee payer don't take on the risk. Instead, it moves back to the old style of working where the limited company must run the IR35 assessment. The limited company must take on the risk for leakage and tax if it's subsequently determined that they were inside IR35 where they've been operating outside. So for a lot of small companies, this is a useful exemption to know, clearly, because it takes a whole load of due diligence out of your scope. And a lot of people rely on it. That's not to say that HMRC may change that in the future. They may pull in the small companies into scope. We don't know. But for now, small companies are exempt. So what is a small company? Well, you are determined to be a medium or large size hirer if you hit two of these following criteria, two or more. annual turnover is more than 10.2. Your balance sheet is more than 5.1 million, and you have no more than 50 employees. If you hit two of those criteria, i.e. you've got more than annual turnover of 10.2 million, your balance sheet is more than 5.1 million, or you have more than 50 employees, then you are deemed to be a medium or large size hirer and the rules apply. If you do not hit two of those, then you are deemed to be a small hirer and the off-payroll rules do not apply to that company. The old rules apply. Now, two important points to consider here. First of all, and perhaps most important point, is that you are assessed for this purpose as part of a group. Therefore, if you're a subsidiary and there is a group structure, for the purposes of the medium large size hirer assessment, you have to take into consideration the group as a whole, not your subsidiary. That's an important point. The second point is that you need to keep an eye on your company status. We've seen a lot of instances where there's a small company exemption applied. The company goes through rapid growth, as we've seen huge growth in the recruitment sector over the past year or two. These companies rapidly grow and they forget about this, given that they haven't got the right processes in place. They tick over, they continue working through that period. And if they continue working through that period for long enough, they're considered to be a medium and large size company, then they're going to be exposed to the risk that comes with not doing the assessments. i.e. if you took on 10 contractors on an outside IR35 basis, but they were deemed to be inside, you've got the tax liability on your company for 10 employment taxes. It's a lot of money. It's a lot of money to hit very quickly. So we need to be keeping a close monitor on the size. Now, you do have some grace period on that. The rule is that you have to hit it for 2 consecutive years, financial years. And then if that's the instance, you have to start doing it in the following tax year. So you do have a bit of a grace period. It's not kind of, I've hit the point and now I have to assess, but it's something to keep an eye on. Let's keep monitoring over your small to medium company exemption, especially if you're on the cusp of that. So those are who it applies to. So just to summarize that slide, any consultant providing their services through a limited company or partnership, tick. Moving on, is the company a small company? Yes. Then the limited company does the assessment, the consultant. If the company is deemed to be large, then the hirer is doing the assessment and takes on the risk. So moving on, we now know who it's deemed to be applied to. Now we need to understand how it's assessed and how it applies. And this slide really looks to highlight some of the key aspects. Now, when you're assessing IR35, it's very much a what does it look and smell like? It's not a defined set of criteria, which is part of the problem of why it is so difficult to make a proper assessment. Remember, though, the importance is that you showed reasonable care. We'll come on to reasonable care requirements later on, but you need to, in terms of being a limited company, if they need to assess, or being an end hirer, assess with due care and attention to these points. And these points come from precedent, like court cases that have happened in the past, which have helped determine the IR35 outcome. So supervision, direction, and control. Clearly, you can take those 3 words and apply them directly to the situation. They're fairly obvious in what they're trying to say. If a client has no right of control in the manner which the PSC performs the services, then that for me sounds like a business-to-business relationship, i.e. the limited company is supplying the end hirer with services. They're not providing a person to provide those services. If you're providing a person to provide the services, you're inside IR35. If you're providing a business, an outsourced function, business to business relationship looks more to be outside IR35. So when we're looking at that, then we need the consultant and the end hirer to agree what needs to be done at the beginning, at the start of the assignment. And then for the consultant themselves, i.e. the PSC, the personal services company, determine how the work is best completed. Ideally, that PSC will also determine pretty much when and where the work is actually done. But we all acknowledge that in a lot of big businesses, there's a requirement to be on site. There's a lot of rules around the work, how you can conduct the work. So again, it's workplace to workplace dependent. It's not just one size fits all. It's very much individual assessment. But ideally, the PSC would determine how they are conducting the work, how it's best delivered. They're the expert. That's the reason you brought them in.
Not that, is it? So that's a cross.
Right. If you look at that, and on the opposed side, if you look at that from an employment perspective, is a manager supervising, directing, and controlling the way an individual works within the business? In a typical employment situation, a manager would say, you need to do this. They'll go away and do it. Still how they think the best way. They'll come back and then they'll be directed again to the next. But there is an element of control in there. That feels more like an inside IR35 engagement because it's more a person being provided to perform a service, not a business. So that's how you can start to look at supervision, direction, and control. How is the contract running? What's going on? The next one is personal service and substitution. Personal services is pretty much where a PSC has an unfettered right to use any resources it chooses to complete the services. And that typically indicates an outside IR35 assessment. Now, we've spoken about supervision, direction, control. They can decide how it operates. What we're talking about here is resources. The PSC should be able to deliver the resources it needs to complete a task set by the end hirer. If you think about that from an employment relationship, it's typically the employee themselves who's going to work every day. It's them who's performing the work. It's them who's getting it done. They can't send someone else in their place. So therefore, if we're looking from a self-employment perspective, we're looking at, can the PSC bring in substitutes for the person that was typically working on the assignment? Or can subcontractors or helpers be brought in to complete the services and make sure you're delivered by the time frame? There should be no requirement, ideally, that the worker, i.e. the worker within the limited company, is him or herself required to personally provide the services. I do understand, and from a commercial perspective, it's very difficult sometimes to do that, given that there's very niche services being provided and you are typically going to someone for their expertise. But the question is, are you going to a business for their expertise, or are you going to an individual? And that's the central question you need to be thinking of yourself. We're not trying to get around the situation here. We're not trying to say, well, if I did this, then I would be this. What we're saying is, what does the engagement look like? And that's the determination. That's the only way you can stay compliant in these circumstances. Don't look at it as, how can this be outside? Look at it as, what is it? And then make the decision from there. So is the limited company able to bring in substitutes, subcontractors to complete the services? Next on the list is mutuality of obligation. And again, quite a bit of weighting being provided outside the kind of typical spheres by the courts on this. It's not particularly technical. It basically just says that where, let's say, an employee, let's look at a self-employed arrangement, the client, i.e. the end hirer, is not on an obligation to continually keep providing contracts over and over again to the PSC. In an employment situation, we would expect that the employment continuity means that the employer is required to provide more work. to identify areas where that employee needs to work in the business, to provide once one task is done to move on to the next task. Neither the limited company nor the end hirer should assume continuity of a contract which just rolls on and on and on. That would be mutuality of obligation, and where the contract is deemed to be expected to just continue being renewed on and on and on, then that looks to be more like an employment relationship and therefore inside IR35. So that's important. What we would expect to see is that the PSC would have no implicit or explicit obligation to accept or undertake any further work on behalf of the client. So once an assignment ends, the client can't expect that the PSC will agree to another assignment. They're not expected to be there. Another assignment can be agreed and implemented before the end of the contract. More terms can be agreed, the scope can be changed, the deliverables can be changed, the length of time can be changed, but that's a new contract. The continuity and the expectation of continuity lends itself more to an employment situation. So that's looking at mutuality of obligation. We've touched on substitution already. And the final one there is office holder. Clearly, if you are an office holder and the worker is undertaking statutory responsibilities, so company director, company secretary or board member, those roles look very much like an inside IR35 contract. Now, particularly in the media industry, there are continuity programs where experts are brought in to implement a position for a short-term period, whilst long-term notice periods are being worked out to move on. I'm aware of that. And in some instances, it's not deemed automatically inside IR35, but it must be considered that there is a key deliverable to going in and providing some interim support there. What you're not going in and doing is acting as a director. If you're a continuous director for a company, that looks very much like employment. So another one to be careful, especially when we're talking about senior members and expert members, where you're an office holder, it looks to be inside IR35. So the remaining considerations on this slide now start to look at self-employment where they're present. The first is business of your own account. So where a limited company can show it's operating as a genuine business, and I come back to that point around business to business relationships, it's more likely that the assignment would be determined to be outside IR35. So the PSC and the client should have a clear understanding that the PSC itself operates as an independent contractor. And a good example of that would be where the PSC has its own premises, for example. That can be a home office, doesn't need to be a fully fledged premises, but where it has its own independent space, that seems to be more a business to business relationship. Other indications are where the PSC is actively marketing its services to other clients, has its own website, has its social media presence. These ideas kind of contribute to a feeling of business to business relationship rather than business to individual. Financial risk on there. Financial risk is difficult to quantify in these circumstances, but generally the more financial risk that the limited company is taking on, the more likely the assignment is determined to be outside IR35. So, for example, if the PSC is duty bound to remedy its mistakes, pay for those mistakes, or takes on liability for those mistakes, it sounds again more like a B2B relationship and therefore would be determined to be outside IR35. Where there's no indemnities or where the individual contractor is not duty bound to pay for any mistakes they made, then it's starting to sound more like an employment relationship, so it would be deemed to be inside IR35. So again, financial risk is to be considered there. And then finally, nature and length of the engagement. It's not the be all and end all. A lot of people typically ask questions around, I've got a contract for 3 months, will it be inside or outside? Can't answer that. Typically, I've got a contract for a year. Will it be inside or outside? Can't answer that. The length of time in its own is not a factor for determining IR35 in and of its own. You can have a deliverable program which is delivered over the course of a year. You can have a program which is delivered over the course of three days. That's not what we're looking at. We're looking at how that contract and how those deliverables are met over the course of that engagement. So nature and length of the engagement doesn't necessarily impact it, but clearly if you've got a key deliverable for 3 months and you've got no mutuality of obligation, i.e. there's no contract after it, that's looking pretty good initially in terms of a self-employment arrangement of a business-to-business relationship. So those kind of summarize the considerations. Are there any initial questions around those points before I move on? I know we've kind of rushed through a fair amount of the information there, so I don't want to.
There's nothing coming through on the chat that
cool.
I can see, so I think
that's fine.
Carry on.
Good. Okay. So the disagreement process. I promise that that's the most kind of in-depth part of the presentation as well. So for those who are kind of glassy-eyed, I promise it's not too much longer. The worker, i.e. the limited company or the individual, has a right to challenge any status determination that the hirer creates. So the rules are that in the supply chain, if you are deemed to be a medium or large size entity, you have to create a status determination statement and pass that down the chain. If there's a direct engagement with the consultant, therefore, you, as in the company, have to create the status determination statement, which will say, this is the factors that have determined you're inside IR35, or this is the factors that have determined there's an outside IR35 engagement, and you need to pass that down to the chain. So if there's an agency in the chain, you need to pass it to them. They then need to review it and pass it on. And this is another point of why I'm saying it's important for you to have a transparent supply chain and everyone talking to each other. Everyone needs to know how the working practices are moving. Everyone needs to know what everyone's duties are, so that we're not causing any conflict into what different parties are thinking, because that just invites risk. So step one, issue a status determination statement. Let's assume, for the purposes of this discussion, that there's a direct engagement between end hirer and consultant company. The status determination is created by the end hirer and then passed down. Once the limited company has the status determination, and let's say it's inside IR35, but the limited company determines that they think they're outside IR35. They perhaps had their own independent review conducted. They've thought about it and they think they're outside IR35. And again, this is a point to transparent supply chains. If the working practices for the consultant are different or deemed to be different to how the end hirer thinks the contract is going to be run, there could be a difference in opinion on inside or outside IR35. So where we can get that kind of streamlined approach to everything and everyone knows what page they're working on, we're going to skip out a lot of this disagreement between the parties and create a much more harmonious working arrangement. So the worker does have a right to challenge. The hirer, i.e. the company, must respond to any appeal within 45 days and must set out the justification for the decision, or where they are unable to justify their decision or want to change their decision, must reissue a new status determination statement. This is important for end hirers who are implemented blanket assessments. It is not allowable under the reasonable care rules, but for companies which say we're deeming every role and here to be inside IR35, consultants will naturally disagree with that process, and then the end hirer will have to go through this whole assessment again, will have to justify the reasons for their decision, and they cannot simply justify it by saying, just because we think so. They have to show reasonable care that all of the steps have been taken. So this disagreement process is going to be invoked quite a lot, and end hirers should be super careful on this, that they're listening to their consultants, because the disagreement can be verbal. If you're on a call and they say, I disagree, I think I'm outside IR35 for these reasons, you've got to react, and you've got 45 days to respond. So end hirers need to be thinking about this. Consultants need to be using this where they have information, documentation, considerations that they think lend themselves to a different determination than the hirer has determined for them. It's a good tool. Unfortunately, there's no real, it's requirement in statute, but there's no real provision after that if there's a determination or there's a reassertion of the outside IR35 or inside IR35 decision from the end hirer. There are other things you can do with the tax return, and you can challenge the determination through a tax return. But I think for the purposes of today's discussion, those are a little bit more in depth. So if you go through the disagreement process and it's reasserted, but you're dead certain that you're still outside IR35, drop us a line and we'll talk through it in more depth in that kind of side room, because it is quite in depth and quite novel. Reasonable care. I touched on reasonable care earlier, but it's an important point to cover for the purposes of the end hirers.
Sorry, Reece, can I just jump in there? Because one of the questions probably comes back a little bit to that, which was quite often, I suppose, in the industry what we're doing is things happen quite quickly. They're looking for someone to go in next week. We've got the skill sets here, limited companies, consultants. What happens if there's not, when you look at the contracts that are coming across, the question is where there's not an official contract covering some of those services that are to be delivered, what happens then? What's the position for the limited company? Because quite often all gets agreed, clear on what we need to do, but then the contract might not reflect that. So
absolutely.
What do you do in that situation?
So funnily, media and veterinary are two areas that we work in quite a lot, different industries, but incredible amount of similarities in that there is very commonly either no contract when the services are performed, or the contract is effectively backdated to cover off the contract after it's been performed due to the speed. In those instances, I mean, as an advisor, I would always advise against that situation. For me, a template contract is so easy to implement that I would, if I was the consultant, I would have a template contract on a B2B engagement ready to go, where the end hirer isn't giving me one, so that A, I'm protected, B, I know how the operation is going to work, and C, it's more likely to protect myself for IR35. So if you need template contracts or things which you can create immediately, then let us know. That's point one. But in terms of the IR35 assessment, what happens is, as I say, the end hirer is under obligation to conduct the assessment and provide a status determination statement to the limited company. In the event they don't do that, in the event they don't provide anything, until they provide that status determination, all risk is on the entity that's supposed to have done the status determination. So let's say for the purpose of this discussion, there's a limited company, there's an agency, a recruitment agency in there, and there's the end hirer. The end hirer is deemed to be medium or large, and they're supposed to do a status determination statement. If they don't do one and pass it to the agency, for the remainder of that contract, they are liable for the leakage of tax. So that's the risk that the end hirer is paying. If the end hirer is determined to be small, then the limited company is duty bound to do the assessment, and they need to do it. But in all of this discussion, what I think you can see is that IR35 status is not determined by the contract alone. IR35 status is determined by the working practices, how the engagement is due to be run, how the process is to be delivered. And that's really important, because if you don't have a contract in place, you can't see how the engagement is going to be delivered. So you as a consultant, if it's a small company, need to be thinking, right, I need to be ticking these boxes to make sure my outside IR35 status is correct. Otherwise, I could be at risk of liability with HMRC. As an end hirer, you need to be thinking, right, well, there's no contract in place. I'm at risk already of liability, but I need to be making sure that the consultant is operating in these ways. Otherwise, I'm at risk of liability on tax as well. So if you're not going to put a contract in place, and I understand that for the need of pace, that being said, I think there is every reason to just quickly put in place a template engagement contract, and particularly where you're a consultant, to stop any risk of liability in the future. Then you're back to looking at the working practices. How is the contract to be performed? How is everything to be delivered? And you need to be making sure that what you're determining, if you're running a limited company and you're paying yourself in dividends from the contract, you need to be thinking, right, I'm paying myself in dividends. I need to make sure I'm operating as if I was outside IR35. I need to make sure all of this contract is determined to be outside IR35 or I'm at risk. So that's how it comes from two perspectives. If there's no contract on your assessment, that's how you should deal with it. But if there's no contract, then the company is deemed to be large, then the end hirer is going to be the responsible party. Hopefully that answers your question.
Thank you.
So reasonable care. As I say, clients are required to exercise reasonable care when they make the determinations. And again, failure to take reasonable care determines that that liability sits with the entity that didn't take the reasonable care. Reasonable care is defined, and you'll see most of it in HMRC's guidelines as well. But that's, for example, asking someone within your company to make the assessment that is not sufficiently knowledgeable in IR35. HMRC have confirmed themselves that using the CEST tool or the CEST is not particularly fit for purpose. They said that in, they didn't say it was fit for purpose. They said it couldn't be relied upon in court. HMRC said that. So taking reasonable care looks to me like understanding IR35 fully, detailing how you made those steps, detailing the pillars that we discussed, detailing discussions you've had with each other party in the supply chain, and determining the status as a collaborative effort to say, we're maintaining this is how our working practices are going to operate. From there, continuously maintaining it. So let's do a 6 monthly check to see everything's correct and see all the working practices are tight. Everyone's sticking to the same thing. There's no change in determination. There's a new contract. Let's do the same and make sure, and keep continuously checking. Recording those decisions and recording that information is imperative. Write it down. Again, I know that the pace of things determines that sometimes contracts can't be created. Sometimes this is a burden. I'm telling you, the risk financially and commercially to you as an end hirer and as an individual is huge, and it shouldn't be seen as a burden. I say that very difficultly, I know. It has to be seen as a necessary process for you to implement into your businesses and to your processes. If you're going to be a freelancer, it has to be. The risk is too great. So record those decisions. Even if you're a consultant and you don't get to speak to the end hirer on it, record it. Say, this is how I'm setting everything out. WTT Legal conducts all the assessments. We record all our assessments onto a blockchain. That blockchain then is sent to HMRC where there's an investigation. So we know irrefutable proof that those decisions were taken at that time by those people in communication with these people. This is how it was to run. Reasonable care, big tick in the box. You can replicate that yourselves if you don't use a third-party legal advisor such as WTT. You can replicate that yourselves by making long notes saying, this is how I'm running it. This is how my engagement is supposed to run. This is how I'm engaging with my client. This is what I'm doing. This is how I view the engagement to be. If HMRC knock on the door and you've done all of that, you've done a CEST tool assessment, you've gone through everything, you've looked at the contract, you've looked at the working practices, it's likely HMRC are going to put you in the too difficult box and move on. And that's what you're looking to try and achieve, getting as much information and as much determination to make this as tight as you can in the determination. Now, whether that's inside or outside IR35, it matters not. What you've got to do is make the right determination based on the facts. Don't try and jimmy things into other areas to try and make it sound right. It's not the right way to do it. HMRC will see through that. What you need to do is answer the questions based on what we've discussed today. And if you need any help at all, there are loads of advisors. I, for one, will always help people work through this and chat through it, particularly for Liberty Hive community members. So please do reach out and just have a chat through things if you're not sure on particular points. But reasonable care is important. Finally, we're talking on statement of work. Statement of work is an alternative working arrangement, which a lot of people are starting to use. And the reason I've added it in here is because WTT are experts on it, but mainly because it's starting to be used more widely and you might start to hear it cropping up. So it's useful for you to have a small amount of information on it. This isn't particularly in depth, but a statement of work is a business-to-business arrangement, again, which sets out a fully outsourced, output-based service. So it is not the supply of labor. It's not companies providing an individual to a company. It is not hiring or providing personal services. It is a business providing a fully deliverable outsourced function to another entity, another company. Now, that results in more risk for the limited company. It results in you providing it's definitely outside IR35 because you're not providing individuals, but it is commercially beneficial again, because again, where a statement of work is implemented, the off payroll rules don't apply to that end hirer anymore. The end hirer is the entity providing the outsourced service. So where a statement of work is put in place, for example, between media company 1 and media company 2, before media company 1 was outside IR35, media company 2 needed to do the assessment. If there is a statement of work put in place, now media company 1 is doing the assessments for its subcontractors who are providing the services. They are the liable party for the purposes of the legislation. They are duty bound to do the assessments and take on the risk. Media company 2 is not within that chain for the purposes of the legislation. So that is another way that companies are looking to change their working model to provide a much more comprehensive provision, deliverable based service, which slots in, provides a service for a period of time, and it extricates itself. And by doing that, you take on more risk. You're operating as a business, but by doing that, you remove risk from the previous position, the previous company determined to be the end hirer. Clearly, you can see how that would work in the media industry, and I do think that there's going to be more and more interest paid into that space. So I do think you're going to start to see the phrase statement of work coming up a lot more. If you haven't already, I'm sure you have already. If you need any help on that, we like to consider ourselves experts in that particular field above all else. So if you need any help there, come and have a chat with us and we'll talk you through it in more detail. But I think for the purposes of today, I just want to get across that it's out there. It is an option for companies to consider to be pivoting their approach. Just labeling something its statement of work when it's really a kind of a provision of supply of labor, is not going to work. It's just not going to work. It has to be a genuine business to business outsourced provision, but it's out there and it's happening, and it is a factor for when we're considering IR35. So come and talk to us if you want to talk through it in more detail. And that's it. As I mentioned at the start, we are considering putting in place a little mini series of IR35. I know it's a boring topic, but it's an important one, and looking at how we can break these kind of component parts down into more specific areas. So please do give your feedback to Liberty Hive, and there's any areas you'd like fleshed out a little bit more, I'd be very happy to record a video or jump on another webinar and talk about them in more depth. Similarly, my contact details are there, reese.thomas@wttconsulting.co.uk for more information, and wttgroup.co.uk for our website. On that website, you'll find lots of resources in the search box. If you type in statement of work, for example, or you type in IR35, you'll see lots of blog articles about it. We have lots of videos and things for you to check out if you have any other information, if you need any other information on stuff like this. But that's where you can find that information. There's no charge to chat to me. I should make that clear. I talk to any Liberty Hive members for free. We'll talk through it. I really love talking about IR35. So it's no burden for me. Do come and talk to us whenever you want and talk through it. But I'll stop talking for now and hand back to Kate.
Well, thank you very much, Reese. There's lots of thank yous coming in, and it is a hard topic to get your mind around. Certainly, Laura and I still a year on. There's stuff that is new or reminds. It's always good to have a reminder on these things. Reese is there to support us. We're very lucky to have that access. And again, he's covered a lot today, because I'm very conscious that there's consultants on this call, but there's also some employers. So trying to cover both sides is always a bit trickier, and you have to go into a bit more depth. But as you say, if you go to his website, you'll be able to find certain areas that might be helpful as well for you specifically. Or get in touch with either myself or Laura at Liberty Hive. Thank you very much for your time today.
Yeah, and we'll be sending out a recording as well. So once you've all digested all the information, then you can filter any questions to me as well, because I'll be following up.
Excellent. And I'll get those flow charts over to you, and they break down into kind of 5 stages, the considerations and some of the detail. Basically puts an hour webinar into 1 page. So good, yeah. I'm largely superfluous, but the flow chart will be much more helpful, I think. So we'll send those over, and hopefully anyone who wants those, grab hold of them.
Brilliant. Thank you, folks.
Thanks very much for saying that.
Thank you all.
Brilliant.
Thank you.
Cheers, bye.
Thank you.